I would like to begin by sort of talking about the finance research on issues such as disclosure, which is very similar to the issue of consent, right? When you buy a financial product, you typically, there are many things written on some page and you say, I agree to all these terms and conditions. And then you find many years later that the product that you bought was actually missold, or the person that had sold you the product had not told you the truth about the product. And a lot of the literature on whether humans can make decisions, whether there is an information overload, whether there is bounded rationality, emerge from those sorts of problems on consumer protection in finance. And I think that we are seeing similar problems in the data protection space, where you are being asked to make these kinds of split decisions on, whether you consent to XYZ or not, and you're just given a binary choice, which is, yes you do or no you don't. And I think that the way the consent model is constructed is a problem today, because it's not constructed in a way that people can understand what they are signing into, and it's a very binary choice, yes or no, and you can't say that for these things I'm giving you my consent and for these things I'm not giving you my consent. And the third reason that consent becomes more difficult is because of this time lag between when you're giving data and when you find out what has happened to the data. And it's a similar analogy with finance, right? So you buy a product today, and only 10 years later will you realize whether this was a product that you bought, because the features of the product will play out over 10 years. And I think that's part of the problem with consent as well, that I may say yes to something today, but I don't know, and many a times the data controller himself or herself doesn't know what is going to happen to the data, and this time lag sort of makes consent very difficult. So, I've laid out the problems of the consent model to begin with, but I'd like to sort of caveat by saying that it's not that I think that we should go, completely to the other extreme of having no consent at all. And maybe when we come back to that discussion, I'll put forth my views on that.
I want to sort of start perhaps with sort of three provocations around the notion of consent. We're all familiar with the Supreme Court judgment sort of finding a right to privacy inherent in the Article 21 sort of right to individual liberty. And I think similarly we must find inherent in that, to realize these notions of privacy and individual liberty, a notion of individual agency and self-determination. And if we do away with consent, right, we are doing away with that agency, that self-determination, that ability to control the data of oneself and about oneself. And so I think that consent is critical to that sort of rights-based framework, as it were. But I think that we can't stop at consent. Consent is a starting point. It's where the user sort of first indicates their wishes and their beliefs around sort of how their data should be controlled, managed, processed, and so forth. But we need to have more steps around that, right? I think that the sort of rights-based model sort of draft that's been sort of floating around by Rahul Matana has sort of pointed to the need for there to be more accountability. And in that regard, I agree with what's been written, that it can't just be consent-based, that once I check a box or say, sure, by visiting your website, I agree to your terms. We need more links in that chain. We need transparency. We need training and education. We need rules around sharing, around breach, and so forth. And so I think that we need to sort of think of that consent as the first link in the chain. My second provocation would be to say that users send many signals. And I think that it's incumbent upon us, especially those in industry who process user data, collect user data, to listen to those signals, to look for those signals. So we believe, for example, that when a user opens a private browsing window in Firefox, they're saying, I want to be private, right? And so we do not allow in private browsing mode for third-party trackers, for font trackers, for any number of other sort of tracking services to load, right? Which is different than some other browsers out there that sort of still allow those trackers to load and then dump the session data at the end of the session, which still allows you to get fingerprinted in the process. And so I think that you have, two equally good, hopefully equally good, browsing experiences you can use regular browsing mode or you can use private browsing mode. But we sort of saw that signal from the user and we chose to act upon that and sort of enable that from a product perspective. And then my third sort of provocation that I wanted to put out is the notion of, is consent really broken? When we say consent is broken or consent has failed or consent's not working, depending on how strongly you feel on this topic, I think we have to ask, do we have a problem with consent in implementation? Right? That when, for example, the EU specifies that you have to notify your users that you're using cookies, and we get these sort of annoying cookie banners that don't actually enable any meaningful choice or meaningful privacy. Do we have a problem in implementation, or do we have a problem with consent as a principle of law? And I would argue that we have a problem with implementation.
One is that I agree that there is an element of autonomy and self-determination inherent in privacy within the liberty paradigm. But I also want to make a case for paternalistic regulation a little bit. And the reason really is some of the things that Renuka was saying, that there is an information asymmetry problem. Sometimes users don't have all the information that they need before making decisions. There's a bounded rationality problem even when information is given to users, which is that they're not able to process what they're told easily. And I would add to that, it's a somewhat information asymmetry problem, but there's also a predictability problem, right? Earlier in the day, we were talking about AI and about how fast technology is moving, which means that a lot of the time, technology companies are in a place in which they've collected data, but they want flexibility to play with that data, because what they come back to you with is, if we can't experiment, then we can't give you new services. But the trouble over there again is that nobody is able to foresee what is coming, and any harms that might emerge, as Malvika so beautifully illustrated in some of her responses, a lot of the harms that might emerge are often invisible. So you may not necessarily make the link between a harmful impact that you are feeling because of your lack of privacy and what you consented to. And so from that point of view, this is the reason that regulators are not completely consent-based all the time, and there is a degree of paternalism in which the state makes certain decisions for you. So that's one, right? Two is this interesting question that the recent privacy judgment raises, which is, Justice Chandrachud acknowledges in his judgment that there are elements of privacy that are clearly fundamental right, and then there are elements that are not necessarily. And so especially within the data protection debate, I think that going forward, one of the interesting questions to ask will be what parts of our data and what manner in which our data is collected, aggregated, used, etc., would fall within the realm of the fundamental right, and what parts of it would fall within property-related rights. So it's basically you're treating it like property and you can negotiate with it. And the reason I say that is that if it's a basic right, then sometimes you're not permitted to give it away. Other times there are certain circumstances in which it can be eroded. And then according to the judgment itself, the state is obligated to enable you to protect your right to privacy, even when a private player, when it's a private actor that violates your right to privacy. So that's a consent question really that the judgment itself flags. And then the last one is that even if we're talking about giving consent, right, to the limited, as Renuka said, we can't think of this in binaries. So there are circumstances in which we will be dealing with a consent paradigm. Then the question is that what are the different devices that we can use to enable consent? So sometimes transparency works, but it doesn't work if the user is not in a position to process the data. Can we think in terms of audits and other devices that would enable users to sort of understand what they're consenting to, or to use sort of broader framework saying this is a group of things group of activities or group of companies that can use my data. So there are ways in which users can be empowered that doesn't necessarily involve their processing the data. So consent can be enabled. But this judgment, it's raised a really old constitutional law question, which is that 4 judges have signed up to a judgment, and that's the one that really lays out the standard that we've all been discussing. But the thing is that the other 5 have written their own judgments, which yes, say there is a right to privacy, but now the question is, what is the standard that we're going to follow? So my caveat here is this is what the 4 judges signed on to, okay, the restriction that I'm describing to you. So one is that there has to be an actual law according to which your privacy is violated, the law has to serve a legitimate state aim. And that's an interesting phrase because it's not used in Indian law really. So that's going to get interpreted God knows how. Well, fun times for lawyers, what can I say? And the last one is that the manner in which the restriction takes place, it has to be proportional. And so there's quite a lot of administrative law jurisprudence about that. So I think a lot of litigation is really going to be around that. And so what we've got is a broad principle and a way in which the right to privacy can be restricted. Now, the specifics of procedure that will be followed for phone tapping, for Aadhaar, for other erosions of privacy, that will be developed by the judiciary in the future, using perhaps the standard, if they choose to accept this one as the standard emerging from this judgment, what it means specifically, right? So if I can give you an example from phone tapping. Old standard, the court said that you can only violate the right to privacy in limited circumstances, and then it came up with what it said was an interim safeguard. It set up a system in which a very senior bureaucrat issues an order, and then it's reviewed by 3 secretary level people, also very senior. And that's it's been accepted by the government as the reasonable procedure. It's followed, the Telegraph Act uses it, the IT Act uses it. And the thing is that if you think about the number of phones that are tapped and the number of interception orders that are sent out, it's the most ridiculous process that I've ever heard of, because these are not people that have the time to check tens of thousands of orders, right? They're the senior most civil servants. So the reason I'm saying that this is relevant is that sometimes you have a broad standard that looks great, but the specific institutional safeguards that are developed, that really determines whether your right to privacy will be protected or not. And that we don't know what is to come, but it's important to understand this so that we can work towards actual accountability, which this panel highlighted.
I want to respond to something that Chinmayi said. I agree with her that she said that you have to go beyond consent and be a little paternalistic as well. And what I wanted to do was sort of just highlight the challenges in going paternalistic, right? So it's one thing to say that I will have a regulator, and I'm sort of quoting from the document on the Mathan document, if you will, which sort of says that there will be this regulator, for want of another word, who will do these third-party audits of your algorithms or of your data, and come in ex ante to see if there is a harm that is going to be caused or a harm that is caused. And if it finds that a harm is caused or is going to be caused, it can come in and intervene and stop you from using that data in a particular manner. That's my broad understanding. I hope I am correct in that understanding.
Sorry, this sounds a little odd to me because I don't know of any company that will be willing to share their algorithm with a regulator.
So there's this process, and the paper outlines this thing called as learned intermediaries. And apparently, maybe Yochai has more knowledge about how this is done, but apparently there are these learned intermediaries that you don't have to show your entire algorithm to, obviously, but that can sort of come in and learn or understand what it is that you are up to. My worry with such a paternalistic model is that in India or anywhere in the world, we have a big challenge of regulatory governance. So while consent is maybe broken, setting up good regulation is equally broken. We really don't know how to design good agencies, how to do checks and balances within agencies, how to design accountability frameworks so that our regulators also don't go overboard. We've seen, we work in finance, and we've seen innumerable instances of problems within the financial sector regulators where orders are given without any reasoning. Okay, so this is an ongoing problem that we are battling with. We know problems of rent seeking in many other sectors as well. So when you give power to the state to walk into and preemptively take action so that harm may not be caused, you are opening up another box of problems. And so, my response would be that yes, consent is broken, but regulatory governance is equally broken. And between two broken problems, what would you rather solve?
Sorry, I'm mentally face palming right now because I don't know what to do with the situation. Do we have a solution?
No pressure, right?
No.
So, challenges of regulatory governance notwithstanding, I do think that a strong data protection authority has been critical around the world. in helping to sort of ensure the realization of rights to privacy and data protection. And I think especially as, while we have sort of some pieces of law here and there in India that sort of speak to data protection in limited fashion, like as a, comprehensive data protection law comes into being, having a strong privacy authority, I think, is generally helpful and can help to cover some of the gaps that might emerge as sort of this first exercise happens. That said, I think that we need to absolutely sort of pay attention to the regulatory challenges. Is the regulator sufficiently independent, sufficiently competent, has sufficient ability to sort of gather data and intelligence to fulfill their enforcement mission? And we wouldn't want the challenges that have been seen within regulation and regulatory bodies to say, we don't need enforcement and we should just push this all to a self-regulatory mechanism. Clearly, we need to have strong enforcement if privacy is to be real. So I think there's sort of that point. I think that there's also no single silver bullet that if you do this thing, then your citizens' privacy will be protected. Privacy is sort of a holistic and broad and big challenge that requires a lot of different things by a lot of different sort of participants in the ecosystem. So I think we need strong sort of ex-ante regulations sort of to compel businesses to protect privacy and sort of set rules of the road. I think that we need to empower regulators and the government. I think we also have to put limits on the government. I mean, the government has access to a tremendous amount of information and sort of a disproportionate asymmetric power vis-a-vis the citizen. And so I think that we need to be mindful of that. And I think that we also need to deal with the actual education side of this too, right? I've talked about transparency. You need to be very clear with the user about what you're doing. I actually think that's not that hard. As I was saying earlier today, I think you need to be, when you have a data collection or data processing choice, you need to be clear about what the user benefit is. And if you don't have a user benefit, then you probably shouldn't be doing it. And so I think that you can tell that. I mean, so we, for example, have a program called Test Pilot. Encourage you to all check it out. It's a lot of fun. It's where you can see all the hot new features, right? This is where we are doing that experimentation, right? When things are not ready for general release, right? And someone has an idea for a new feature, and we want to get some data to sort of say, is this viable? Are there things we haven't thought about? There's a segment of people who have opted in with, and they also have to opt into each individual experiment to be a test pilot and try out those new features. And then that's generally gathering more data than what your general release user will be, processed by. And then we can learn from that and we can develop things like that. And so I think that, sorry, if I can, two other sort of ideas, I think that obviously literacy is a big challenge. So I think that we can and should do more experimentation with sort of speaking, permissions, spoken prompts, and sort of interacting in that way. The EU GDPR, the General Data Protection Regulation, also includes a series of sort of icons. And so that might be something that may be useful or adapted to try and help convey in different ways in different places how this data collection and processing is happening.
Someone mentioned in a discussion yesterday that an antivirus software company once decided that instead of complicated terms of service, they would clearly indicate to users what data they were collecting, et cetera, et cetera. When users found out what they were actually collecting, they moved elsewhere.
Again, this is something similar within the financial sector space that we have dealt with, which is that normally you expect competitive forces to solve all your problems. But when there is information asymmetry, or when there aren't enough sophisticated users who can discern the difference between a good privacy policy versus a bad privacy policy, firms will have no incentive to put out a good privacy policy. And sort of that brings back the case to why we should have paternalism mechanism. But there are 2 points that I do want to add to what Yokai said. He mentioned empowering the regulator and independence and all of that. I want to add 2 metrics of accountability that we would like to see in regulators. And for example, we've done some work on looking at the legal framework around Aadhaar, and we worry that some metrics are missing when the UIDAI has assumed such a large function. One is to have performance metrics around the regulator itself. So whenever we do have a data protection regulator, how do we think about sort of evaluating what has this data protection regulator done, what would be a good performance metric? And secondly is certain accountability provisions about what they can do, how they can do certain things, when can they intervene, when can they not intervene, what kind of cost benefit analysis they should do. All of this is extremely hard, but I think that in this whole landscape of regulation and data privacy regulator, we need to push for these kinds of measures. And I want to respond to what Malvika said, and I completely agree with her about the principles that should govern any privacy law. And I just want to articulate a couple of principles that we've thought of. I'm sorry, we work in finance, so most of my examples are going to be in the context of financial regulation, but I think that they apply to data protection as well. So for example, the draft Indian Financial Code lays out a principle that says that financial contracts cannot have unfair contract terms, or you have to have fair disclosure. Financial service providers, I replace that with data controllers, cannot do unfair conduct. So these are just timeless principles, if you will. And these are something that we can build on in the data protection space to say, what does it mean to not have an unfair contract term? And that's when consent becomes meaningful, because when the contract term is fair, then I can meaningfully, or at least begin to process what I'm signing up to or not.
It's unfortunate the ombudsman function that was supposed to be able to at least pull the plug on the Aadhaar system if it were to malfunction, that was removed before the legislation was passed. But there was a lot more to it that I feel is a useful cautionary tale when we're dealing with the new Data Protection Act. And that is that, I don't know if you remember, at the point at which the Aadhaar Act was passed, there was a lot of literature going around saying it's wonderful, it's so strong on privacy and data protection, look where we are, right? And the reason is that it used a lot of language saying that that privacy of data should be maintained, etc., etc. And that's why I say it's a cautionary tale, because I think that one of the things to watch out for with the new data protection law is this similar tendency to use data protection privacy sort of very wildly, almost like a PR strategy within a legislation, but not to create actual accountability. So the question that we should keep asking ourselves is, who do we go to if something should happen? Right? And this is bearing in mind the entire ecosystem, that a single company does not hold its own data, it subcontracts its data to one person who subcontracts it to someone else, etc. Through that entire supply chain, there needs to be clear accountability that is accessible to the average Indian citizen, because point number 2 is litigation is expensive in India, right? And so that's also something to bear in mind when we're building consumer-oriented frameworks, to bear in mind what the burden on the consumer is. Because so basically, if we don't do all of that, what we'll have is this data protection legislation that keeps using privacy but is effectively ineffective.
So in the context of where India wants to be 1 billion users online, more than half of them will be low literacy, and the question of consent in that context, and you brought up one example of agreements where there should be fair terms, and there have been example of buyer-seller agreements which have been overturned. When it was clear that there were terms hidden deep inside which the buyer may have agreed to. So I'm just wondering if there are examples of limitations on consent, just the same way as there is statutory rape, which says you cannot have a minor who consents to sex as far as the law is concerned. Okay. There are also some other examples where this comes up, and I'll just give one which is not directly related here, but I don't know if you're aware of the Uttar Pradesh new Marriage Registration Act as of this month, which basically allows registration by OTP. There is no physical presence required. Yeah, so this is the new Uttar Pradesh Marriage Registration Act. You do not need to go there. You do not need witnesses. You do not need a wedding card. I think it's progressive. So both the parties, they just have to log in on their phones on an app. They log into this site. They get an OTP. After that OTP, they pay 10 rupees and they get the digital marriage certificate. This is live now, okay? And I've gone through a demo of it. I mean, I haven't done it, but I have. Okay, so here, of course, there is consent, but there is a question of the context of that consent. Were they drunk when they were getting the OTP, etc.? So I'm just wondering if. By the way, the divorce is not that simple.
Sorry, but both sides get an OTP, right?
Yeah, two OTPs. But the
At
point
least
is,
that. At least that.
But seriously, you could be drunk. One party could be drunk or whatever. So there's a so similarly, low literacy person agreeing to sign off a whole lot of rights just because the person on the other side is apparently a government representative saying that, oh, you have to tell me all of these things or sign off to an app or whatever. So my question, the starting point was that are there examples of limitations to consent of this nature anywhere in the world? Just like there is statutory rape, which provides a certain limitation based on age. And I'm sure maybe the age limitation might even apply in terms of consent for various other laws.
So, I don't know if there are limitations on consent. However, what I do know is that several jurisdictions have limitations on, for example, what data you can collect for what purpose, what do you do with that data once you have collected it, and that sort of plays along in how consent can get designed, right? Because if you can't collect data for XYZ purpose when your purpose is ABC, then that consent, the way the consent is designed, it becomes more meaningful. But I don't know of any offhand instances where certain consent policies have been designed in a certain way. However, the one point that I do want to add is that, again, in the financial context, one way that we did think about financial regulation is to think about sort of a class of, for want of a better word, unsophisticated customers. And we said that these unsophisticated customers would have higher rights. So for example, there is something called as, suitability advice. So I have a right to a suitable product, and that's if you are in that class of customers who can't make up their mind about a complex insurance product, for example. So that's one way to think about consent and all of these other limitations, which is that perhaps greater restrictions apply when you are dealing with certain customers who you think can't make up their or are not able to very quickly make up their minds. But again, this is a process that has to evolve. Just because I don't know something today doesn't mean that 5 years later I still won't know it, right? So there is a certain process of evolution that we need to think about. And in fact, Chinmay made this point when we were standing outside about, and I'm sorry to steal your thunder, but the fact that we need to evolve over time in terms of how we think about some of these issues.
See, I think the one thing everyone's forgetting is that what consent and what it's being used for and whether a contract is fair is going to be a determination under the Indian Contract Act. So it's nobody else who can determine it, and that's going to go on forever. But and fairness, everything is going to be the battle is going to be in the courts, if at all, around that. And I don't think that the consumer is in a position to be able to actually come in and battle that out as effectively and in numbers that are required. Maybe because of allowing class action suits, there is a possibility that you can actually come together. But let's look at the insurance sector as an example. You take medical insurance for the first year, you can't really claim. That was passed by a regulator, because every scheme has to go through a regulator. So, private sector may say, yes, it works, regulators don't work well, but it also doesn't work well for citizens and consumers. When we look at self-regulation, I have a question for generally private sector and everyone in the room, is would private sector actually look at saying, because we've never gone out and said, let's pay those who are our regulators and fund our regulators more than what they get today. Have we incentivized for the best minds in industry or in society to actually be able to join these regulators? Is it a career of choice? So we say that, we want better regulators, but are we willing to actually go out there and say our regulators need to be paid more, our MPs need to be, so that we can actually create strong professions out of these? For example, Singapore pays market-based salaries to their regulators, bureaucrats, and everybody else. You know, so I think everyone takes advantage of the situation of saying that, but we don't try and address the real problems then. I'd like a feedback from people here and saying, you know, would they look at models such as this, you know?
I mean, I don't know whether we should be discussing solving the regulation problem
No,
from
I'm
a
looking at
payment to regulator perspective.
Self-regulation versus, I mean, the key is this. Self-regulation in the broadcasting industry is a fantastic example. So you end up having to live with both Republic TV on the one side and you have an Indie TV on the other side. That's a everyday example of self-regulation. I mean, when the Indian Broadcasting Association was formed, the reality is it's accountability.
So I think that's a different debate because there have been issues there as well. Over accountability, you can argue it either way. Sorry, Murari, yeah. So
Sorry, I didn't mean to jump, but it was sort of related to the point that he was going to make, which is why I thought it's... So this whole concept of learned intermediaries, right? We have to be very careful because the last time something like this was supposed to work, it miserably failed when the financial crisis happened. Because you have these two rating agencies that are supposed to, rate these, complex tranches and all that, and they miserably failed. And it sort of goes back to the point that he was making. On the one hand, you have one guy who's trying to figure out what the hell is going on. On the other side, you have these highly paid, brilliant, probably 15 PhDs trying to, tell this guy why whatever he's saying doesn't make any sense, right? So you have to have a level playing field. Anytime you want to go for strong data protection agency or anything like that, that problem that he's talking about is going to come into play because it's not a level playing field. You have to assume that the companies will almost always have, more money thrown at this than a regulator, in which case it's sort of set up to fail and it won't really perform the function that, that's being intended here.
I'd just like to spend a little bit of time just on figuring out what consent is. And for me, the history of consent has been the last 200-300 years has sort of come in. So the internet and consent and privacy is new, but there's the consent word and its perspective and model is actually fairly old. And for me, the gold standard which came out was in the 90s and 2000 around medical information and research. So to give an example of what the diamond standard of consent looks like, you want data from somebody, great, write up a proposal, why you want this data, where will this data go, what you will use it. You will then send this to an independent research board, we'll call an IRB, and they exist in most universities and a lot of you have had to subject yourselves to them. They will then say, okay, we allow this research project, you can collect this data and this is what you can do. You then go, you enroll your participants. You have to give a concept called informed consent, where you have to sit with them, explain to them what you're doing, why you're doing it. When this informed consent came to India, they were asked to record it, that you have to prove that you got informed consent. So you have to take a camera and you have to record these sessions where you explain to them every single thing in a local language. Once that's explained, finally they sign on it. That signature has to have usually a witness and hopefully videographed. That is what the diamond thing of consent looks like. Today,
it doesn't scale.
It doesn't scale. I'm saying, but that's what the absolute extreme. The other absolute extreme on this side is, okay, one screen, this small, 2-3 things there, couple of icons, and okay.
Scrolling bar.
That's a little bit this side. At least make them scroll down the entire thing and click okay, right? So when here you have this consent and you have that consent here. My question to the panelists is for you, at what point do we say we have arrived at consent and this is a legitimate consent given by a person? Is it informed consent at this stage? Or is it just by clicking OK is at this stage? Now please also remember, when you're giving informed consent, there is a notion of active consent, and which has become a huge issue right now thanks to the marital rape laws and all, and sexual harassment and assault, where they're saying that if you consented now and you said you have to keep seeking continuous consent throughout the experience, otherwise at one point you are now in sexual assault or sexual harassment, right? It's an active consent, it's an informed consent system. To me, the one thing which I'll add to it is that, in my opinion, and this goes back to the legal contract system, that if it won't hold up in court, it's not real consent. If you can't take that terms of service agreement, etc., and take it to a judge and say that this is a de facto consent contract between us. And so a lot of laws yet have to be framed. I'd love to know people's thoughts. At what point do you say, this is enough where consent has been given and informed consent has happened?
That,
I'll dive in.
I'm glad I don't have to answer this question.
So, for me, I would start with where the GDPR came out. I think there was a pretty robust conversation around that. So the GDPR text says, consent to the data subject means any freely given, specific, informed, and unambiguous indication of the data subject's wishes by which he or she, by statement or by clear affirmative action, signifies agreement to the processing of personal data relating to him or her. Yeah, so that means like a tick box doesn't work, right?
I'm sorry to interrupt, but part of what my problem with the consent infrastructure in place today is exactly that. It's obfuscating language.
Mm-hmm.
And when the language is designed to either confuse or obfuscate the person from whom consent is being acquired, that's bad faith.
Let's like, I wouldn't go so far as to say that like the legislative process was conducted in bad faith, but I completely agree with you that is way too much legalese for a user, even a very savvy user.
It's like boring a guy into saying yes.
Yeah, so I think the question is, so what does this mean, right? Like, what does this look at practice is sort of where I was trying to segue from that by reading that out, right? And I think that one of the things that we're seeing this both in the GDPR debate as well as in the current e-privacy regulation sort of debate that's playing out in Europe right now is a couple of sort of very practical implications. One is you can't do tick box consent anymore. You can't like have that little box that's already checked. You can't do by scrolling down this page, you have consented, or just by hitting this page, you have consented to our terms. You can't offer it like I think the EU is saying very strongly, you can't have a take it or leave it approach, right? Either you consent to our terms or you don't use our service is not viable as an approach anymore. I think so. What this legalese sort of focuses on is sort of what are these ways in which users are making a sort of an affirmative action that they actually understand, that you've provided the transparency and the information in order to do that. And in some cases, especially in low literacy environments, we're going to need to have new ways of communicating these things to the end user. And I think that the current debate, and this has not been settled, in the European, in the privacy regulation sort of question is, if they reject it, should they be still allowed to use the service? And sort of, can you use, some services are not going to work as well without the personalization of cookies. I would actually be okay with that for some services, right? And so do you need to offer that? I think that there's a question of sort of like, can you offer an equivalent service, right? That's not the sort of shitty privacy, or the totally exploitative, one. But, so for the way we have tried to do this, has been to sort of say you have a, regular browsing mode and you have a private browsing mode. And so when you are choosing and opting and sort of having that greater level of privacy, you have an option and that's relatively easy for the user, very understandable. And we sort of regularly give prompts about that to the user. And I think we got to figure out ways. I think there's also in the GDPR a requirement that companies now start to have very easily sort of understood, plain language, very simplified terms of service, and we're already seeing that sort of converting over. And I think that's progress in the right direction. I don't know if that's the end state, but I think we're sort of getting there, and I think that again moves to that sort of point. Can I pick up on other comments, or you want to? Should we give Chinmaya a chance?
No, I just wanted to make a tiny point that I think. We don't just want to look at consent from a apps or browsing perspective, because we're talking about data here. It could be healthcare data, financial credit data. You don't have a private browsing mode for healthcare data, right? Or could you? So,
not yet.
All yours.
I'm not aware of any plans for a healthcare browser, but who knows? It's a large company. It's certainly possible someone's working on that. So no, I say that as an example, right? And I think that that's the type of thinking that we need to be doing in terms of what are the offerings here. I think that we have raised a lot of challenges in this discussion around consent, and I think that that's why privacy, I think, usually starts with consent, but it shouldn't end with consent. We need stronger protections that are hard-coded into the law, that have obligations on the data controllers and processors, regardless of sort of what the user has signed away or not, or has consented to or not. And so I think this sort of narrow focus on just consent as the end all and be all is sort of too narrow and does not reflect what I think sort of the ideal privacy data protection framework should look like.
The analogy that I was going to use, just because there's a case going on right now, is like a classic example of how consent should not work, both in terms of, I guess, the invasiveness of the privacy right involved, but also it's just, I guess, an obscene example is, marital rape. You consent once, and then you're not allowed to withdraw, like without divorce, which is, and it's basically you raised the question of ongoing consent, right? And I feel like this risk-based approach, active, ongoing. So basically, you don't assume that one round of consent is consent the next time. That can be important depending on the degree of invasiveness that we're talking about, right? So the other thing, somebody asked me a question last week, and we did the session on Puttaswamy and NLU Delhi, and someone said that would you create gradations of privacy? Are some violations of privacy more serious than others? So I said, yes, there are. So how would you create the standard? And honestly, I think that would be very hard to do right now. But that there is a difference between different kinds of violations of privacy is very clear. I don't think that's disputable. Example number 2 in this context would also be that sometimes what you can say is we're going to come up with a consent paradigm, but the implementation of that consent paradigm might be almost impossible, right? So you take something like a website that is not permitted to display intimate pictures of people without their consent. Now, if you don't require that the consent has to be written, proved, etc., in exactly the manner that you say, then what you will have effectively is a lot of people's consent being violated because basically the burden of proof has shifted. So that's something to consider in how we build a consent paradigm. The other thing that I wanted to pick up on, which Yokai brought up earlier, and then I feel like we dropped it, is also that in our desire to come up with paternalistic broad brush regulations that apply to everyone, etc., I don't think that we should forget the role that design plays in refining consent. I thought that was a great thing that you said about Mozilla and innovation. And so I say this again because a lot is going to come back to the data protection regulation, which is not going to solve all our problems. I'm sure that there will be spin-offs in terms of litigation and sectoral regulation, maybe differentiation between size of companies, kind of data we're talking about, etc. But what's important to remember also is that as we're regulating in favor of privacy, we also want to incentivize companies to come up with better ways of seeking consent and of protecting privacy, and it's important to build that into our regulation. The last one, and then I'll stop here, is that I think that we're at a great moment in terms of thinking about privacy and data protection. I did not expect while entering here that we would solve all the data protection problems in India. We're not going to. But personally, I've learned a lot about ways in which we can intervene in the process. And that's really the best that we can hope for right now. We're going to make mistakes, but it's helpful if we're informed and we learn from them.
Anugrah from Change Alliance. I was going to put forward a solution because you were asking for solutions, but I now realize that my solution is probably not that great. I'll put it forward anyway. So we were talking about the limitations of learned intermediaries, and I'm trying to find a middle ground between what you described as the diamond standard and the yes and no thing that is obfuscated. Yeah, that you
obfuscated.
Obfuscated. This is coming from the humanitarian sector, from which I come from, and we developed the core humanitarian standard for international aid agencies. And what we found in how to get accountability in our aid system, one of the ideas was to use color coding. So if you had, for instance, the principles that we talked about through the morning, you have principle A, B, C, D, and you have color coding. If you have those learned intermediaries that are actually able to say this on this long 20-page contract, terms of service, on this principle it scores a green, on this principle it scores a yellow, but on this principle it scores a red. So for instance, I don't mind my intimate pictures being displayed, whereas he does. So for me, that principle will, for him, that principle will go up as a red flag. But I can see that principle as a red flag, but I don't mind, so I will give my consent, whereas he won't. And so if I see not just an app, but also across the entire ecosystem, if I can see a code that gives me a red flag saying, oh, there seems to be a problem in this area, that color coding may be a possible solution. But I understand it's a bit simplistic.
Actually, it reminds me of an idea which we had during the net neutrality debate of taking all the submissions from everyone who had submitted, all the major players, especially industry, and rating and ranking them on how they were faring when it came to the net neutrality principles which we had proposed. That way, what it also does, it creates a competitive scenario where people will try and improve things.
Would it not make it better if they just like mandated everybody to put their terms of agreement simply and explaining why they're collecting the data, what they're going to use it for, and because they are going to collect data, right, at the end of the day. So you might as well explain in the simplest language and then see, because now if everybody does it, wouldn't it level the playing field?
Broadly speaking, that's what the GDPR does.
But I feel like your question has two answers. One is the yes, that would be helpful. But two is also to go back to something else that, when you describe what the GDPR says, and someone said English, please, that's actually the trade-off between rules sometimes. So it's basically there's a lot of literature in the framing of rules. And the thing is that the more precise you get, the less accessible the rule is to other people. And it's important to note that there's where the challenge lies, right? You want a rule to be as specific as possible about what people can and cannot do. You want it to have enough flexibility so that it doesn't regulate too closely. It sticks to what the broader objective of the rule is. But the last thing is you also want it to be accessible. And it's not easy.
So we just have 10 minutes, so Yochai.
Sorry, I want to give a slightly more nuanced answer. So I think that we can and will now be required to be more explicit, like as a sector, with privacy notices, right? Like with that sort of policy of like, this is what we're collecting, how we're collecting, why we're collecting, that sort of notice. And I think we're already seeing a sort of trend for this to be, about a page long, about 5 bullet points, and that's a little bit more transparent. I hope more easily understandable. I think that can't be a substitute for also doing sort of just-in-time permission requesting. I think you can't do a privacy policy, even if it's easy to understand and in plain language, and then sort of, wash your hands and say that I'm done here, like my work is accomplished. So I think that particularly when you're dealing with sensitive information, you need to sort of do an in-moment request for information. Be like, hey, do you really want to share turn on your camera and your microphone? Do you really want to send your location data? And there are a number of other sort of examples that we can come up with, but I think that we need to sort of think about a sort of more sophisticated and sort of continuous way of getting that sort of active consent. Thanks.
The temporality question is one dimension. The other is that you need to retain the data for longer than necessary, etc. Right? I feel like this is like a framing of the rule question, which is coming a little bit more from where the Data Protection Act is going. And I'm happy to share the paper with you. There's actually a great paper on the framing of rules themselves. But the rule is not necessarily what the end user reads. So it's possible to come up with a different version, sort of a click-oriented, in-moment, temporally correctly situated mode eventually of communicating the rule. But the framing of the rule has to stay as true as possible to the object of the rule.
Thank you very much for the panel. It's really great to have a constructive discussion about stuff like this. So thanks to everyone in the room. I just wanted to throw in a couple more solutions so that if you're all going away and working about this stuff, if you could I'm writing everything you're doing, saying down as well. So if you have more, please also email me, because I think one thing I'm very curious about is what are the alternatives? Like if we have two models out there and they both seem quite problematic on other levels, what else can we be looking at, right? So if intermediaries are a problem or there's been dysfunction there. Couple of things to flag. One thing that, apart from the US and the UK models and the EU model, you also have the kind of African countries are doing things very differently. So there's all this work around how 18 different African countries actually have a registration requirement for people handling certain types of data. And is there something there in terms of, half the problem here is that everybody collects data, so it seems ridiculous to try and regulate everyone. But I'm not prescribing this, I'm just saying that they seem to have a regime that they are going towards registration requirements in relation to certain types of data, and then everything else you kind of put in other rules. Another example, specifically coming back to the EU, I think the legitimate expectation test is something that is really interesting, and especially with the Supreme Court kind of verdict and this use of that legitimate state interest, it's just important for all of us to kind of think about more. The EU has a very kind of difficult way of thinking about it, but if I can summarize, it's kind of the processes, the person using the data, the company needs to think about, do you have a legitimate interest in accessing this data? So if I'm a healthcare provider, I need health data. If I'm just like a random mobile app that does payments, do I need your health data? That automatically, you yourself have a sense check. Is it legitimate, this data interest that I'm trying to access? Secondly, is it necessary to execute that legitimate interest? Therefore, do I need this data to perform my function? And then lastly, even if it's legitimate and it's necessary, then you have to think about the individual in there and whether it's in line with their reasonable expectations and will it cause harm, right? So it's all stuff that we broadly understand, and obviously you can get deeper and deeper into this. And I'm not prescribing this for India, but it captures all of the stuff we've talked about. So I think earlier you talked about no surprises, right? And that's basically reasonable expectations. Is it reasonable expectation for a consumer? And then you balance it off. So do you balance, if the legitimate interest is higher than the individual's kind of harm, right? Then that's fine. But if the individual harm is really high, then maybe you shouldn't go there, even when both the company and the individual have a legitimate interest in this transaction. So that's just one other thing. And then I think on Murari's point around regulation and state capacity, I think this is something we all worry about. We have all these principles and then, damn, India is India kind of thing. But I think the whole conversation around reg tech is quite interesting here, because if you have a way that people are holding databases, and if reg tech can come in, which is basically regulatory technology, and directly talk to your database, then the Reserve Bank, for instance, to an extent already does this with banks, right? That's how they run their supervision. They use a framework, they do a Spark framework, and that's how they figure out that this bank is in trouble with. And it's all very quiet and secret because we don't want to have a run on anybody. But a similar thing could happen for systemically important databases, right? And that you could actually have, I think it's something to think about there. And lastly, I think like the FTC model after the effect in the US is quite interesting, where they actively launch investigations and stuff like that. That's also a capacity point. Maybe we don't have that much capacity, but if you can set up a kind of stakeholder somewhere in government or outside government, which actually its job is to kind of look at this kind of practice, and it just needs a little bit of money and a couple of committed people there, I think it could go quite a long way, in kind of having this. So just a few things to put on people's radars, that's all.
See, the Supreme Court did a great thing in many ways by articulating the right to privacy, by making it clear that many, many different dimensions of the right to privacy are within the fundamental right to privacy. I think it's important not to minimize what the Supreme Court did from that point of view, because it's expanded the coverage, right? And it's made it clear that quite a lot that wasn't very clearly within the realm of privacy it is. And so from that point of view, if it triggers litigation, then fantastic. This was a long time coming. If we want to be an information superpower, these are the only terms in which we can be one. Two is that has the Supreme Court foreclosed the Aadhaar question? No, because remember, right in the beginning I outlined for you 3 standards, right? There was legitimate state aim, there had to be a law, and then it had to be proportional, right? Now the Supreme Court has been very clear that all 3 boxes have to be checked if you're violating the right to privacy. It gave examples of one category of what may be a legitimate state aim. So national security may be a legitimate state aim, but that does not mean that the manner in which privacy is being violated to secure national security checks the other 2 boxes. And so where I was saying that litigation is going to determine a lot more, it's basically a lot is riding on how the Supreme Court interprets the other 2 boxes in the future. in relation to state action. And so when it comes to Aadhaar, I thought was one interesting thing that they did is they only talked about the welfare components of Aadhaar, and they didn't talk about the other linking to PAN and dying. And I was going to ask about the marriage. Is it possible without Aadhaar? It hasn't talked about any of that, but even the welfare question, right? That is the manner in which it's being done proportional. That's still a question that's up for determination, for the Supreme Court to decide.
There's a tendency to see the internet as a brave new world and that we have to come up with everything from blank. That's not the case. There are plenty of other industries who've struggled with these issues for hundreds of years. They've tried various solutions. It's worth having a look at them. Just 2 quick examples. Renuka's not there, but she had mentioned earlier, for example, there is a program called the International Qualified Investor Program, which people have to go through a process before they are identified to banks as clients who can take additional risk or who can give additional consent beyond a point. And so the QI program does this. Please have a look at how that works, issues as well. The second is the QP program, which the EU has come out with for pharmaceutical as the third-party intermediaries. Post the Moody's blow up, they said third parties can only be single individuals with personal criminal liability, cannot be organizations or thing. And QP people in the pharma companies actually go into factories, look at intellectual property, look at their secret formulas inside their drums, and then sign off on their ability for safety for consumption of human health. And there are thousands of these people now who've been trained. It's a model, but I'm saying we don't have to reinvent the wheel. There's things that have worked and haven't worked. And we should take a minute to go and see those industries and see if we can learn from what their experience has been.
Okay. Slightly legal question that I don't fully understand myself, but so I think Malvika mentioned this earlier. Now, in light of what the Supreme Court said about the right to privacy and grounding that in bodily integrity of the individual, does privacy then get treated, or data, personal data, get treated as part of the individual's bodily integrity, or does it get treated as property?
That's
all you.
So easy. It just, my short answer is it depends. Yeah. Luckily, no. Sorry, one thing that I actually want to use this as an excuse to highlight is that privacy was linked with dignity, which means that there'll be a lot of contexts in which you can't give it up. But Chandrachud was also clear that not all elements of privacy are necessarily of a fundamental right standard, and then also linked to dignity. So so this is what I was saying right in the beginning when I started, right? That slowly we're going to start developing a sense, norms are going to develop about what falls within the fundamental right and what doesn't. So for example, I may be willing to give you consent for cash to take a test that just tells you what colors I prefer. Say you're running a survey, right? It might be an academic survey like the one you're describing. It may be commercial because you want data from a focus group, and I'm happy to be paid to give you the data. Now that's the kind of thing that just, on the face of it, it doesn't look like a violation of privacy. But if what you were taking from me was kind of more closely linked to my identity or to my dignity, then the answer might be different.
So last couple of things. Rahul, what's Google's view on consent?
No, I think so. As a company, we strongly believe that putting users in control is extremely important by giving them meaningful choices. And I think when we talk about consent, it has to be different scenarios. It has to be contextual. So, for instance, if companies have legitimate interest, for instance, to protect the user, so maybe the consent there may become that is something which probably don't need an explicit consent. So, for instance, securing a particular device, right, or checking spams. Then there could be situations where like it's sensitive information, so where probably explicit consent is relevant. In other scenarios, implied consent could be relevant. So it's completely dependent on the context. So I think that's important to keep in mind, and trying to give user as much control as is possible.
Okay, Bhairav, Facebook's view on consent.
I think broadly it will be in line with the idea that
that context-based context-based consent is necessary for different uses of data. The large problem that not just Facebook but most people, including the government or other tech companies, have is that highly formalistic consent requirements sometimes defeat the purpose of consent. That's in fact the central topic. This is what we've been discussing. How to convey, how to inform consumers of what they need to know in order to make informed or some form of informed consent is a central tension in all consumer privacy law, and it's a problem that not just Facebook faces but everyone else does. Internally, there is sustained focus on how to better inform consumers of data uses and practices. And again, I think this is a larger industry concern. This is something that regulators across the world are dealing with, including the FTC in the US. And at some point, if we ever have a regulator over here, this is an issue that should be dealt with as well.
Uttara, what's...
sorry, just, I mean, since you have put us on the blog, so one thing is also because, again, we were talking about the permissions of the apps, for instance, right? So, like from a Google perspective, we have tried to give more control to users in terms of the apps they use. And you can actually now, in the Android operating system, you can go to the settings, and for each particular app, you can actually very simply switch off the kind of permissions the app is asking, selectively, like for SMS, for camera, for voice. So those kind of user controls we are trying to build and gain trust. I mean, that is of essence to us.
Okay. Sorry. Uttara, Amazon's view on consent.
So I echo what Rahul said. I think that we're also very much about giving users control over the data that they're sharing. However, that being said, I think that it's a little bit complicated in some context. For instance, IoT devices, especially when it's interoperable across geographies and across different devices, that becomes a little bit more complicated, but it's a question that we're seeking to address through the multiple consultations that have been issued. So yeah, but we are, as Avinash also briefly touched upon it in his panel, we very much would like for users to have control over the data they share.
Okay, could you pass the mic forward to Mahima from Twitter?
So I work for Twitter, and I think privacy is really built into our DNA because we also allow on our platform people to have accounts that are private, and you don't have to disclose. I mean, that's just a choice we made. It's no judgment on anybody else, but you can really have a public account which is indeed quite private, and you can talk about things that you want to. From the other point of view, of course, we're giving. We have a new privacy policy, which maybe some of you actually got. Preview on email, the rest of you can see it soon enough.
I consented without checking.
Okay, but we give a lot of controls, and you can go back into the dashboard and you can actually sort of tweak that. And I think yesterday at the meeting I was telling people that we had at Twitter a do not track button, like just a do not track. And we thought that it would become an industry standard, but over the years it never did become an industry standard. And now the dashboard is very personalized, and people can really pick and choose what they want to share with Twitter, or what they want Twitter to share with somebody else, etc. So I think from that point of view, it's we're quite strong on that. The other is transparency, which is that as a user, you're using this product, and at some point you might want to know, well, what does this company have on me? Because just offhand you may not realize. And so you can actually check and see, what do we think about you? What's the data that we've collected on you, and what do you look like to us? And you can actually give us some feedback on that. The third point that I want to bring up, which I know has been discussed, but I just want to put it, is consent, of course, users giving it to us, but also in terms of like the data that we are then giving ahead to other people, whether that's the API, which is open API, which people, they do sign a developer policy and they have to adhere to some rules, and they should not be using it for use cases that we do not think our data should be used for, and it's extremely strict even if people are buying this data for us. And so what happens is that if someone has said that we want access to Twitter data because we want to check the health of people in the particular state, but they are actually not using it to check the health of people in the particular state, and they're trying to profile people and see what kind of political speech, we are well within our rights to actually just cut access right there and then, and we will not tolerate that. So it's not just about the users, but it's also about, as a company, moving forward, what is done with the data that we are collecting in good faith from our users. So yeah.
Okay, I've never seen this do not track button, to be honest.
I think it died a natural death.
Oh, it's gone? We can't use it now?
It never became a standard. It never became a standard.
Okay.